of the themes running through your speeches and writings which trouble me. You have openly criticized decisions like Griswold and Roe, which go to the heart of a woman's right of choice. You have been an outspoken admirer of natural law, a doctrine largely dismissed for the past half-century. In fact, you have suggested that, and I quote, "it provides the only firm basis for a just, wise, and constitutional decision." As we all know, the Griswold, Connecticut case guarantees that there is a fundamental right to privacy in the Constitution as it applies to contraception. Do you agree with that decision and that there is a fundamental right to privacy as it relates to contraception? In your opinion, is that settled law?
I agree with the Griswold court's conclusion that marital privacy extends to contraception and availability of that. The court, since Griswold, has grounded the privacy right discussed in that case in the liberty interest protected under the Due Process Clause. That's the approach that the court has taken in subsequent cases, rather than in the penumbras and emanations that were discussed in Justice Douglas's opinion. And that view of the result is, I think, consistent with the subsequent development of the law, which is focused on the Due Process Clause and liberty rather than Justice Douglas's approach.
Well, I'm delighted to hear you say that because, as you know, many constitutional scholars believe that once you accept the reasoning of Griswold and find that the Constitution does contain a right to privacy and a right to contraception, that you've essentially accepted, scholars have said this, essentially accepted the basis for the court's reasoning and decision on Roe, that a woman has a constitutionally protected right to choose. These scholars reason that it follows logically that if a woman's right to privacy and her control of her body includes the right to contraception, then it also includes a woman's right to choose to terminate her pregnancy. I'm not sure whether you wish to comment on that. I just wanted to point out to you something that I'm sure you're familiar with, is that there is, in constitutional thought, a follow from Griswold to Roe.
Well, I feel comfortable commenting.
Yesterday you said this: I agree with the Griswold court's conclusion that marital privacy extends to contraception and availability of that. The court, since Griswold, has grounded the privacy right discussed in that case in the liberty interest protected under the Due Process Clause. Do you think that right of privacy that you're talking about there extends to single people as well as married people?
But the courts held that in the Eisenstat case, which came shortly after Griswold, largely under principles of equal protection, and I don't have any quarrel with that conclusion in Eisenstat.
So, okay.
Judge Alito, you'll be faced with many questions on many topics. I'm going to start today with a woman's right to choose, move to executive power, and then hopefully within the 30 minutes pick up congressional power. Starting with the woman's right to choose, Judge Alito, do you accept the legal principles articulated in Griswold versus Connecticut, that the Liberty Clause in the Constitution carries with it the right to privacy?
Senator, I do agree that the Constitution protects a right to privacy, and it protects a right to privacy in a number of ways. The Fourth Amendment certainly speaks to the right of privacy. People have a right to privacy in their homes and in their papers and in their persons, and the standard for whether something is a search is whether there's an invasion of a right to privacy, a legitimate expectation of privacy.
Well, Griswold dealt with the right to privacy on contraception for married women. You agree with that?
I agree that Griswold is now, I think, understood by the Supreme Court as based on the liberty clauses of the Due Process Clause of the Fifth Amendment and the 14th Amendment.
Would you agree also with Eisenstat, which carried forward Griswold to single people?
I do agree with the result in Eisenstat.
Let me move now to directly into...
Do you agree with the court's outcome, the result, in Griswold v. Connecticut and Eisenstat v. Baird? And you know that they struck down a ban on contraception. I believe it's been discussed earlier. Yeah. So, do you agree with the result in those cases?
So Griswold, Senator, as you know, held that the 14th Amendment due process liberty clause provided a right to married couples to the use of contraceptive devices in the privacy of their own home. And then Eisenstat extended that to single persons.
Right.
Senator, those are precedents of the United States Supreme Court. They've been settled for 50 years, nearly, in the case of Griswold. There are reliance interests that are obvious. They've been reaffirmed many times. I do not see a realistic possibility that a state would pass a law attempting to undo that, or that a court of the United States would take such a challenge seriously.
I have a very simple question for you. Do you agree with the result?
Senator, I'll give you the same answer.
Again, I just want to tell you what Justice Alito said in response to that question. He said, very simply, talking about Eisenstat, quote, I do agree with the result in Eisenstat.
It was an application of equal protection principles.
Well, I know what it was. I'm asking you for a direct, clear, unequivocal answer.
And Senator, I'm trying to give it to you, and as I recall, Justice Alito said the same thing, which is that there's an equal protection argument. Once you have Griswold in place, then it follows, as a matter of equal protection, that the same, what was true for married couples is true for single persons, and that was an application of settled equal protection principles.
I want to tell you what Chief Justice Roberts said when he was asked the same question about Griswold. He said, quote, I agree with the Griswold court's conclusion that marital privacy extends to contraception and availability of that. My time is about to expire. I just want to say I hope that when we resume questioning, that perhaps you can give me somewhat more direct and unequivocal answers in the same way that Roberts, Alito, Justices Roberts and Alito and Kennedy did to the same questions. Thank you, Mr. Chairman.
Senator from Idaho.
Thank
you. In Griswold and Eisenstat, the Supreme Court said that states could not prohibit either married or unmarried people from using contraceptives. Do you believe Griswold and Eisenstat were correctly decided?
So those cases followed from the Supreme Court's recognition of unenumerated rights in the Pearson-Meyer cases earlier. And so what those cases held is that there's a right of privacy.
And do you agree, do you personally agree that these cases, those two cases, were correctly decided? So I'm asking not what the court held, but what you believe.
Right. So so to just go back to Pearson-Meyer, those cases recognized a right of privacy, the ability, one might say family autonomy or privacy, the term under the Liberty Clause of the Due Process Clause of the 14th Amendment.
And with due respect then, Judge, I'm asking, do you agree that those cases were rightly decided?
So I think Griswold, so on Griswold, I think that Justice White's concurrence is a persuasive application because that specifically rooted the Griswold result in the Pearson-Meyer decisions. I thought that was a persuasive opinion. And
do you believe that it was correctly decided?
No quarrel with that.
Do you believe it was correctly decided? Words matter, again, words matter. Yeah. Do you believe it was correctly decided?
I think given the Pearson-Meyer opinions, like I said, Justice White's concurrence in Griswold was a persuasive application of Pearson-Meyer. I have no quarrel with it.
So there's a term that actually both Chief Justice Roberts and Justice Alito used, I believe, and affirmed in their confirmation hearings that these cases were correct. And so I'm asking you the same question. Are you willing in this confirmation hearing to agree that those cases were correctly decided?
Well, given the precedent of Pearson-Meyer, I agree with Chief Justice Alito and Chief Justice Roberts, what they said.
That it was correctly decided?
That's what they said.
Do you believe the right to privacy protects a woman's choice to terminate a pregnancy?
That is a question that...
Thank you, Mr. Chairman. Thank you, Judge. Good to be talking with you again. These questions of fairness and who follows the rules and who are the umpires and do we win at all costs or do we respect the traditions of the game are essentially what's before us. So let's get to it with the 20 minutes we have. And thank you again to your family and everyone who's traveled with you today. Judge Barrett, in accepting President Trump's nomination to the Supreme Court, you stated you share the judicial philosophy of Justice Scalia, your mentor, the justice for whom you clerked. His philosophy is, of course, originalism. Essentially, the idea that the authoritative meaning of the Constitution is what it meant when ratified, whether that was 150 years ago, 240 years ago, but meant when ratified. And I think the American people need to better understand what that originalist philosophy could really mean for their everyday lives, because I think it means our entire modern understanding of certain constitutional commitments around liberty, privacy, and equality under the law could in fact be rolled back to 19th or even 18th century understandings in a way unrecognizable to most Americans. Many of these modern notions are rooted in a landmark case decided in 1965, Griswold versus Connecticut, where the Supreme Court held married couples have the right to use contraceptives in the privacy of their own home. In an interview just 8 years ago in 2012 on Fox News, Justice Scalia said this decision was wrong because under his originalist philosophy, there's no such thing as a general right to privacy in the Constitution. This is a question most currently serving justices have answered. When we spoke on the phone last week, you said you couldn't think of any specific issue of law where you disagreed with Justice Scalia. Do you agree with him that Griswold was wrongly decided, and thus states should be able to make it illegal to use contraceptives if they so chose?
Well, Senator, as I've said a number of times, I can't express a view, yes or no, A+ or F. In my other capacity, I get to grade, but not in this particular capacity with respect to precedent. I think that Griswold is very, 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 very unlikely to go anywhere. In order for Griswold to be overruled, you or a state legislature would have to pass a law prohibiting the use of birth control, which seems, shockingly unlikely. Right. And then a lower court would have to buck Supreme Court precedent and say, we're not following Griswold. Again, seems very unlikely. So I think that it's an academic question that wouldn't arise, but it's something that I can't opine on, particularly because it does lie at the base of substantive due process doctrine, which is something that continues to be litigated in courts today.
Well, just for the benefit of those watching, Judge Barrett, as I think you well know, your predecessors talked about Griswold in detail. Chief Justice Roberts said he agreed with the Griswold court's conclusion. He shared your view that he's comfortable commenting because it doesn't appear to be an area that would ever come before the court. Justice Alito, Justice Kavanaugh said essentially the same thing, that they'd agreed. In fact, Justice Kagan, who you've been citing on the no grading, said, I do, that she's willing to speak to it. And as every nominee has, I do support the result in Griswold. I understand that you're saying to us you're going to be your own justice and that you're very hesitant to talk about this case because it is an anchor to substantive due process. But let me just one more time say, are you unwilling to say, as so many currently serving justices have, that at least Griswold is not wrong?
I think Griswold isn't going anywhere unless you plan to pass a law prohibiting couples or all people from using birth control. And I think the question, because it's entirely academic, because it seems unthinkable that any legislature would pass such a law, I think the only reason that it's even worth asking that question is to lay a predicate for whether Roe was rightly decided, because Griswold does lie at the foundation of that line of precedent. Right. So because Griswold involves substantive due process, an area that remains one subject to litigation all over the country, I don't think it's an issue, a case that I can opine on, but nor do I think Griswold is in danger of going anywhere.
Well, and to be clear about what it underlies, it's not just that Griswold was a landmark case, as you well know. It anchors a lot of modern liberty interests in personal and family autonomy. It was extended to unmarried couples in Eisenstat. It was extended to the right for women to control the reproductive choices in Roe and in Casey. But it was also extended to support same-sex couple intimacy in Lawrence v. Texas, and ultimately that same-sex couples have an equal right to marry in Obergefell. The reason I'm taking a few minutes with this is that Justice Scalia publicly disagreed with or dissented in each and every one of these cases. he wrote in one of these decisions that it reflected the court adopting the so-called homosexual agenda. And just last week, Justices Thomas and Alito issued an opinion stating the Supreme Court needs to fix problems from its holding in Obergefell. So I understand you'll be your own justice, and Justice Scalia's philosophy is significant, but I also think
of the themes running through your speeches and writings which trouble me. You have openly criticized decisions like Griswold and Roe, which go to the heart of a woman's right of choice. You have been an outspoken admirer of natural law, a doctrine largely dismissed for the past half-century. In fact, you have suggested that, and I quote, "it provides the only firm basis for a just, wise, and constitutional decision."